at some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte communications.
Oh, I know. That's a part of Mr. Weinstein's motion for mistrial. Yeah.
And you know, I don't want to be a witness. I mean, I could say that there was absolutely no reason for it, and there was no cause for the state to even have these concerns. But Mr. Melnick can explain, you know, if he was conspiring with me and Mr. Steele to obstruct justice, I doubt he'd want to come in here and talk about it, but the state can ask him about it and get to the bottom of it. But I don't think that's what the testimony is going to be.
Okay,
and I think that's important for the court to know.
Okay. Well, I don't know that whether it's true or not is what matters. It's what it looked like at the time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up. We're going to do some research. We'll get back to you. And by the way, y'all, I know that everybody, whenever we were here last, was that yesterday or the day before? Wednesday. So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings on page 95 on the record before court adjourns for the day is when the prosecution says, hey, by the way, we might need an ex parte or we need an ex parte. And then it is.
Yeah, it's rewind time.
Names and then any exhibits for Mondays.
I think the only, I don't know who is being called. We can find out. Ms. Lovett and Ms. Hilton and Mr. Atkins, who is going to be called? Let's assume that Mr. Copeland invokes again.
Your Honor,
Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So
okay.
we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay. Well, be thinking about what scenarios you'd like to have the court look at.
Yes, Your Honor.
Depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Sharp, you can have the floor.
Yes.
I'm just going to ask a courtesy of the deputies. Could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to have a discussion with our clients.
Lieutenant Walker.
And Your Honor, the state has a matter we need to take up ex parte with the court.
Okay. All right. Lieutenant Walker has been asked.
And Your Honor, the state has a matter we need to take up ex parte with the court.
Okay. All right.
And Your Honor, the state has a matter we need to take up ex parte with the court.
Okay.
And Your Honor, the state has a matter we need to take up ex parte with the court.
Okay. All right. Lieutenant Walker.
It is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte, because people from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out to be.
Yes. So So, as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting immunity. Little did we know that they had already done that and they were going back there to have that other conversation. So that's
okay. Yeah, I mean, I know y'all didn't know the substance of it, but
And wrapping back around to that.
yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that
Well, how did they
occurred
get,
as a meeting, because I told everybody on Tuesday, stand up and tell me anything there is. Did y'all do anything beyond the motion to get the immunity order for Mr. Copeland?
No.
Okay.
So we submitted a motion.
Right. And they have a copy of that. And that's
Right.
all right.
Right.
okay,
That was,
Okay.
and Judge, I also state that at the time, I'm not certain why it would be believed that we were trying to get the warrant or the immunity agreement because Mr. Copeland was under arrest at the time that we stood up and made that announcement in court on the 7th. I think he had already been arrested, I think.
You could be arrested and not have immunity for your testimony.
The judge had already told him he had immunity on the record.
Okay. Well, I don't know. I mean, they're probably just trying to remember it themselves too, but. All right. Well, Mr. Shard, I'll take a look at your new motion. And obviously I'll be looking at Mr. Weinstein's motion. And why don't, Mr. Steele, you plan to have Mr. Melnick here at 9-ish. I don't know whether I will hear from him or not, but okay.
And Your Honor, so that we are, I'm understanding is on Monday, we're having the matter that Mr. Steele wants to present Mr. Melnick for.
Maybe.
Would that be a collateral issue?
Maybe.
Okay. So
if I end up hearing from the two of you on that, I'm not going to make you not be prosecutors in the case anymore. We can hear that separately if I even hear it.
And so would Mr. Steele be allowed to introduce extrinsic evidence of a collateral issue that he's raising about the emails and things of that nature?
I mean, the emails are already in the record. I think he's complaining that at one point, I mean, the emails are what they are. And at one point you said, this was an email to me. And at another point you maybe said, I accidentally got copied on this email, but I think it's actually different parts of the email. I think there's actually an explanation for why that might sound inconsistent, but I'll go back and look at all of the transcripts. But beyond that, I mean, no, I don't think so. I don't know what he's got planned. Maybe you want to ask him, but I don't know if he's talking to you yet. So I don't know. We'll take it up Monday.
That's all, folks.
Yo, hit that like for a deal with Christian. Yo, for a deal with Christian. Smash that bell for the upseas. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DLC. Yo, smash it. Just smash it. Hit that like for deal with Christian.